Julie. Good afternoon. Welcome, everyone. Thank you for taking the time out. So today, for the IIRSM East Midlands branch webinar, we've got Raymond Bone with us, sorry, Ray, to give us an overview of the building safety regs. So the key points that Ray's going to cover is the client duties, three main duties, the declaration, what the PD needs to understand, and the appointed persons. Now, I believe there is quite a lot to go through today, so if you have any questions, please send them through and we'll endeavour to get those answered. If not, you can always send them through and we'll try and respond to you afterwards. A copy of the slides should be made available as well to everyone that's attended. That's great. Ray, over to you.
Okay, thank you very much, Daniel. Good afternoon, everybody. I'll turn my camera off because it just makes my voice a little bit clearer during the presentation. So thank you for joining us this afternoon, and as you can imagine, it's quite a big area to cover. So what I've done is I've put lots of information on the slides, bearing in mind they're going to be available to you after the webinar. And on some of them slides, there is links where you can use them links to go deeper into the information, as I'm just providing an overview for you today. So I hope you find it interesting. If you do have any questions, I think we're going to be pushed for time for answering questions today, but please send them in to Julie at IIRSM, and she'll endeavour to get them over to me, and I'll do my best to reply, pending how many there is, and get them answers back over to you. Okay, so let's move on. So first off, I need to say credits and contributions to the people who's contributed and reviewed this information, which is Steve Coppin at SGS Risk Management, Andrew Leslie at the APS, Andrew Modi, HSE, Andrew Taylor from the Resolve Group, Helen Richmond from the Department of Levelling Up and Housing Communities, and Mark Snelling from Safety Mark Consultancy Services, APS President. So the Building Safety Act was announced in the Queen's Speech on December 2019, following the dreadful Grenfell Tower fire on the 14th of June. And the final version was introduced to the House of Commons 50 July 21, and then the Building Safety Act was granted royal assent in April 22. The Act provided an overhaul to the regulations which set clear pathways on how residential buildings should be constructed and maintained, as well as made safe. Building owners are now required to manage safety risks, and they've now got clear lines of responsibility for safety. And that starts during the design, through construction to completion, and then occupation of them high-rise buildings. They've also introduced the golden thread of information, which is required now, with safety considered at every stage of a building's lifetime, including during the early stages of the planning process. Building owners need to demonstrate that they have effective, proportionate measures in place to manage them safety risks. Those who don't manage their obligations may face criminal charges, and I've got some of them listed out for you later. Architects who's acting as principal designers will be expected to be responsible for a golden thread of information, effectively to maintain an account of how the building has been designed, how the decisions were taken relating to both fire and structural safety. These duty holders are those who procure, plan, manage or undertake building work, and they are named as the client, the designer, principal designer, contractor and principal contractor, as is the same with CDM 2015 regulations. Duty holders are required to actively consider and manage building safety risks throughout the commissioning, design and construction process, and ensure that designs, if built, as well as the building work, complies with the requirements of the building regulations. Of course, the regulations set out that duty holders in the design and build and refurbishment of buildings will be those who, or organisations who commission and the building work, i.e. the client, and those who undertake the design work, the designers, and those who construct the building, whether it's a new build or refurbishment, contractors. The regulations apply to all work which the Building Regulations 2010 apply. So if the building regulations apply, then the Building Safety Act and secondary legislation will apply. The duties of cooperation, coordination, communication and competence are applied to all the duty holders for building work associated with high-risk buildings. The Building Safety Regulator has a range of assessment and enforcement powers to ensure that those participating in the design, the build, the refurbishment of buildings will be held to account and to ensure compliance with the building regulations. I've listed there the provisions that came into force in June 2022, sections A to I. You can see there I've listed them out for you. But the Building Safety Act set out certain provisions. So section 48 of the Building Safety Act just talks about insurance, removal of requirements, provisions under section 160 of the Act, which is housing complaints made to an housing ombudsman, and then the transitional provisions which have now passed. So this chart just gives a visual view of the progress made or the journey undertaken from the 14th of June when the Grenfell Tower disaster occurred through Dame Judith Hackett's review to building a safer future consultation, all the way through to it receiving the House of Commons stages completed. Sure you're aware, once that's completed, then goes to the House of Lords, then gains royal assent, and then it was implemented in May 22. So that's the visual flowchart. Now, I've obviously not listed all of the legislation here, but I've listed some of the ones we're going to be looking at. So the main one, Building Safety Act, the Construction Products Amendment, etc., EU exit regulations, the building and buildings or high-risk buildings, descriptions and supplementary provisions, and then a fact sheet on the golden thread. So again, I've put these on because you'll be able to research these and download them yourselves. Obviously, fire and structural is the main elements of the Building Safety Act. So I've listed there the Fire Safety Act 2021, the Fire Safety Regulations 2022, and then the Regulatory Reform Fire Safety Order 2005. The key message on legislation is homes and flats also comes under the Housing Act, with non-domestic buildings coming under the Fire Safety Order, but there's a link in the middle for common parts of residential buildings. So don't forget the Fire Safety Act and the Fire Safety Regulations will play their part in them projects, along with the Building Safety Act 2022 and the Building Safety Regs 2022. And not forgetting our key legislation, the Health and Safety at Work Act 74, along with some of their legislation, such as the Management of Health and Safety at Work Regs, Construction Design and Management Regulations, etc. So there's a lot to consider. The Fire Safety Act now modifies the scope of the Fire Safety Order, and that's in relation to the structure, the external envelope, flat front doors and balconies for all residential blocks. Risk assessment and information provision requirement, although in many cases it will be manifestly obvious through a visual inspection that the risk to life from external fire spread is not such as to warrant a PAS 998 assessment. The information to comply with the building regs with both dwellings and buildings, non-dwellings, approved document B, volume 1 has been updated to reflect the outcome of the Grenfell inquiry. Much of the approved document B is not retrospective, therefore some changes have been made retrospective by the Fire Safety England regulations, which apply to all residential buildings, and they came into force in January 2023. And we're talking about things like secure information boxes, wayfinding signage on each level, preparing plans illustrating essential firefighting equipment and lifts, i.e. floor plans, and prepare plans illustrating local government, local environment to assist firefighting. So that's where the hydrants are, dry risers, access to them, etc. And plans need to include key firefighting equipment. And if you add all them together, it ties in together with the golden thread requirements of the Building Safety Act. I've put some additional fire safety information on there for you. So Regulation 38 of the building regulations is the fire safety information. The regulation applies for new build or relevant change to a relevant building. A relevant building is one which requires the fire safety order to apply. Always had to provide common parts fire safety, but that's now extended to the externals, balconies, flat front doors, and the structure of the building. So if you change a fire door in a building, you now have to provide the relevant fire information to the responsible person, and if it's a high-risk building, the golden thread. The need for some of the golden thread is the same information as is required under the fire safety laws. We're going to go through some of that information. But the main aim of Regulation 38 of the building regulations is to ensure that the person responsible for the building has sufficient information relating to fire safety so that they can manage the building effectively. Therefore, compliance with Regulation 38 is achieved when the person responsible for the building has all the information to enable them to do the following. Understand and implement fire safety strategy in the building, maintain any fire safety system provided in the building, and carry out an effective fire risk assessment of that building. Regulation 38 puts onus on the person carrying out the work to give fire safety information to the responsible person no later than, and I put A and B, A, where the proposed building or extension to which the building work relates is not occupied during the building work, or B, in any other case, the date of completion of work. In addition, the responsible person must give the person carrying out the work a notice acknowledging receipt of the fire safety information and confirming the information provided is sufficient to enable them to understand, operate, and maintain the building and the fire safety system within it after the building work in question. So slightly to differ from the slides, I was having a conversation yesterday and somebody informed me that the BSR are currently looking at a prosecution where falsified documents have been issued under Regulation 38. So someone's signing off documents that shouldn't have been signed off, saying they've received information where they've not received information. So it'd be interesting to see how the BSR deal with that one. What type of information or essential information is to be provided to the responsible person? Well, I've listed out some of the main points there for you. So an as-built plan of the building, which should show escape routes, location of any fire separating elements, including cavity barriers, fire door sets, door sets fitted with self-closing devices, locations of fire and smoke detector heads, alarm call points, detection alarm control boxes, alarm sounders, fire signage, emergency lighting, etc. Any sprinkler system, including isolating valves and control equipment, any smoke control systems or ventilation systems with a smoke control function, any high-risk areas, for instance, them what's housing heating machinery, or places of special fire hazard. In addition, details should also be provided for all of the following: specifications of any fire safety equipment provided, including the routine maintenance schedule, any assumptions regarding the management of the building in the design of the fire safety arrangements, and any provision enabling the evacuation of disabled people, which can be used when designing suitable personal emergency evacuation plans. Excuse me, I've got a bit of a cold and where I need to cough, I silent myself out. So let's not forget about the Fire Safety Order, or the Regulatory Reform Fire Safety Order 2005, along with the Fire Safety Act 2021. So the fire safety order, the regulatory reform fire safety order, was initially written with a commercial industrial premises in mind, where premises is primarily a workplace. The fire safety order would then apply to the whole building, and fire safety is linked with other aspects such as dangerous substances or dangerous processes. The Fire Safety Act amends the Regulatory Reform Fire Safety Order with the intention of improving fire safety in multi-occupancy domestic buildings. Crucially, the external walls of a building and the fire doors to individual flats must now be assessed as part of the requirement for a risk assessment. So this slide is giving you some interaction of how the Building Safety Act and the fire safety interact. You can follow the orange line down to all buildings, or the green line down to high-risk buildings. As you can see, building regulations for high-risk buildings, the golden thread regulations, all comes down into these boxes. You can see the Regulatory Reform Fire Safety Order, which was revised in May 22, next revision April 23, that's happened. But you can see the difference here. So I've left that in, you feel free to follow that. And then we talk about fire safety documents. I was saying to Daniel as we started this presentation that there's so much information out there. It was knowing what is important to put in and what's not, because it's such a wide scope at the moment. So rather than go into detail in each one, such as tenants on fire risk assessments, tenants on maintenance records, testing of evac equipment, etc., I thought a flow chart would show that better than I could explain it. So the Building Safety Act is made up of 6 parts, which is an introduction, its regulator and its functions, the Building Act 1984, the higher risk buildings, and other provisions about safety standards. And part 6 finishes it off with the general provisions around commencement, etc. I'm not going to read all these verbatim. I'll just give you an overview. So part 1 just explains the 6 parts that I've done. Part 2 contains provisions about the safety regulator, what its functions are in relation to the buildings. Part 3 is where it amends the Building Act 84. And then amendments made by Part 3 is in Part 4, which is in Part 3, but Section 4, which provides the regulator is the building control authority in relation to high-risk buildings in England. So any high-risk building in England, then the regulator would be the building control authority. B, require the regulator for England and the Welsh ministers to establish and maintain registers of building control approvers and building inspectors. It's a little complicated reading that, but basically if it's a high-risk building, then the regulator is the building control authority. And to ensure where it doesn't fall into that category, they've now created a register of building control approvers and building inspectors, where they had a deadline to register their individual or their company through an assessment process to come onto that register. So if you're looking at works, what's not high risk buildings, but it could be a CDM project requiring elements of the Building Safety Act, and you need to appoint a building control, then you must check that they have been registered on the BSA's website. Part 4 is about occupied high-risk buildings in England and puts on additional duties on the accountable person. And then Part 5 contains other provisions, including remediation and redress, a new homes ombudsman, power to make provision about construction products, further provisions about fire safety, provisions about regulation of architects, and provisions about housing complaints. And then the general provisions is in Part 6. So the regulator and its functions. The Building Safety Regulator, it talks about what this means. The Health and Safety Executive, although they're trying to come away from that. schedule contains amendments to the provision of the Health and Safety at Work, etc. 1974, that relate to the regulator. But the regulator's objectives and regulatory principles are that the regulator must exercise its building functions with a view to securing the safety of people in or about buildings in relation to risks arising from buildings and improving the standard of buildings. 2, in exercising a building function, the regulator must have regard to the following principles. That's regulatory activities should be carried out in a way which is transparent, accountable, proportionate and consistent. And the regulatory activities should be targeted only at cases in which action is needed. Part 3, the Building Safety Act is construction, applies to new build or refurbishments, but mainly all new building work. Part 4 is in occupation, so in scope buildings, high risk buildings, residential part of buildings. What is a high risk building? There's a bit of a better picture later, but it's any structure which is 18 metres high or 7 stories and has 2 or more occupied units, of which 1 has to be occupied. A building safety risk is a risk to safety of people in or about a building arising from any of the following occurring as regards the building: the spread of fire, structural failure, or any other prescribed matter. The new regulatory regime regulates and holds to account those participating in the design and construction of new buildings and the refurbishment of existing buildings. The regulations apply to all building work and all persons participating in that work. The provisions also apply to those appointed under the Construction Design and Management Regulations. When CDM applies to building work, those appointed under CDM 2015 will be deemed appointed under the building regulations, but only if they've got the necessary skills, knowledge, experience and behaviour. The provision will also ensure that when buildings are designed, constructed or refurbished, all duty holders, including existing duty holders identified in CDM 2015, will have formal responsibilities for compliance with building regulations. I'm not going to go into too much detail on this slide, but I'll look at point 2. So higher risk building means a building in England that is at least 18 metres in height or has at least 7 stories and is of a description specified in regulations made by the Secretary of State. The regulations may be in particular define a building or story for the purpose of that section and make provision about how the height of a building is to be determined for those purposes, providing that the higher risk building does not include a building of a specified description. A lot of jargon there. Remediation of certain defects or meaning of a relevant building. This is the remediation. So relevant building means a self-contained building or self-contained part of a building in England that contains at least 2 dwellings and is 11 metres high or has at least 5 stories. And I put a link there if you want more detail or more information on other provisions. That link should work even in PDF, so if not, type it in. Liability of officers of body corporate. Where an offence under Part 204 is committed by a body corporate, it's committed with the consent or connivance of any director, manager, secretary or other similar officer, officer of the body corporate or any person who was proportioning to act in any such capacity or is attributable to any neglect on the part of such person, and that person as the body corporate commits the offence and therefore is liable to be proceeded against and punished accordingly. So I'm jumping now on to the new Part 2A, which is the Building Regs Amendment England Regulations 2023, and it created a new Part 2A, Duty Holders and Competence into the Building Regulations 2010. I've listed out the most important ones, so 11A, A client must make suitable arrangements for planning, managing and monitoring a project, including allocation of sufficient time and other resources, so as to ensure compliance with all relevant requirements. Arrangements as to information, i.e. higher risk building work. Go on to 11B. Client must make suitable arrangements to ensure information is provided to the designers and contractors working on a project, which includes any high risk building work, to make them aware that the project includes higher risk building work and the nature of the higher risk building work. 11C, where the client is a domestic client, the duties in regulation 11A 1 to 3 and 11E to 2 must be carried out by either the principal designer or the principal contractor. 11D, where there is more than one contractor, it's reasonably foreseeable there'll be more than one contractor who will be working on a project. The client must appoint in writing. That should be nothing new. That's what we do in CDM in any case. 11E, the regulation applies where a person is proposing to use any other person to carry out any building work or design work. And 11F is the competence, so any person carrying out building work or design work must have the requisite skills, knowledge, experience and behaviours, etc. Competence principal designer and competence principal contractor. So I've flashed through that fairly quick because I wanted to make sure I mentioned, I think it's further on in the slides, but BS 8670 is the general competence for frameworks which should be used. PAS 8671 is the competence requirements for principal designers, and PAS 8672 is the competence requirements for principal contractors. And I would apply that as on CDM as well as higher risk buildings. There are elements that would be applicable. So I would include that. What I'm seeing in industry is the PQQs are still getting sent out where they've not took into account the BS or the PAS document competence requirements. I've also got a thing with PQQs where they'll ask if they've suffered any prosecutions in the past 5 years, but they tend not to ask if they've suffered a fee for intervention, which is, in my opinion, relevant. So there's a hint there if your PQQs. And that moves us on to duty holders regulations, where we look at the accountable person and the principal accountable person. So an accountable person is an organisation or individual who owns or has a legal obligation to repair common parts of the building. Common parts are used by residents, for instance, the structure and exterior of the building, corridors, lobbies, staircases, etc., etc. An accountable person can be a freeholder or estate owner, a landlord, a management company, resident management company, a right to manage company, common hold association, etc. A principal accountable person is someone with each building must have one clearly identifiable accountable person who would be known as the PAP or the principal accountable person. Principal accountable person is usually an organisation like a common hold association, local authority or social housing provider, and in some circumstances an individual can be the PAP. For example, the individual is the owner of the building or named on a leasehold as responsible for the maintenance of common parts. The golden thread, which is set out as part of Regulation 11A. So the arrangements made by a client under Regulation 11A must be suitable arrangements to ensure compliance with the requirements, etc., of the building regulations. Must include where the work is high-risk building work or a stage of high-risk building, arrangements for an electronic facility to be created and maintained by the client, procedures for persons involved with design or carrying out work to have access to the facility for the purpose of maintaining the golden thread, where the work is to existing high-risk buildings, arrangements for an electronic facility which holds the golden thread information has to be maintained, and procedures for persons involved with designing or carrying out work to have access to the facility for the purpose of maintaining the golden thread information. The client must ensure the golden thread information is kept in an electronic format, is capable of being transferred electronically, is accurate and up to date, is available in a readable format, is made available as soon as reasonably practicable, is secure from unauthorized access, is only changed in accordance with the procedures, and as far as reasonably practicable uses language, terminology, and definitions which are consistent. The principal designer or sole or lead designer must ensure designs for the building work produced before a building control approval application for high-risk buildings, a stage of high-risk building work or work to an existing high-risk building is submitted, are provided to the client, and the client must ensure before the construction phase begins, or in the case of a stage of high-risk building work, that stage begins, that the facility referred to in paragraph 1 is updated to include the design. Where building control approval for high-risk buildings work, a stage of HRB work, or work to an existing HRB is granted, the client must ensure before the construction phase begins, or if it's a HRB, in a stage, or in the case of a stage of high-risk building work, the stage begins. The facility referred to in paragraph 1 includes a copy of the fire statement, where the work to a high-risk building work or a stage of high-risk building work, a copy of the plans and each of the other documents for the proposed high-risk building, which are approved under Regulation 78B, Building Control Approval Applications for High-Risk Building Work or Stage of High-Risk Building Work decisions, together with all the evidence recorded to show compliance with the applicable requirements of the building regulations. And where the work is to work to existing high-risk buildings, a copy of the plans and each of the other documents for the work which are approved under Regulation 15.8b, Building Control Approval Applications, together with all evidence recorded to show compliance with the applicable requirements of the building regulations. Excuse me. So that moves us on to the safety case. Reasonable measures must be taken to manage the risk of spread of fire and structural failure to prevent their occurrence and limit the impact should an incident occur. The aim of the safety case regime is to ensure that those responsible for buildings, i.e. the accountable person, deliver a continuous preventative and proactive approach to managing building safety risks. The accountable person will be the individuals or entities responsible for meeting the statutory obligations related to the management of building safety risks in occupied high-risk residential buildings. Accountable persons will need to demonstrate building safety risks are being managed proportionately for each building, rather than assuming the following guidance or prescribed standards will result in safety outcomes. This should enable a more effective approach to managing building safety risks, both in terms of outcomes and costs. The safety case is all the information the principal accountable person and accountable person will use to manage the risk of fire spread and the structural safety of the building. The Building Safety Regulator has published guidance on safety case and safety case reports to help those who will have duties under the Act to get ready for the regime and manage risks effectively. The information is designed to help those who will have duties under the Act to prepare for the new regime. And I put the link on there, which will take you to the safety case and safety case reports. They contain information and advice on what the Building Safety Regulator will need in any submission. The guidance covers building information, identifying building safety risks, risk prevention and protection information, safety management systems, and the safety case report. So I've put an example on here in layman's terms because it just makes it slightly more easy to digest. But let's say a structure must implement fire and structural safety requirements as part Part 3. So an example, a designer designs a breakthrough of an internal wall which provides a compartmentalization for a fire water supply to a fire sprinkler system. The designer has stated a specific fire-passive fire protection material for sealing the wall and providing the required fire compartmentation. The designer should ensure the stated material complies with the Building Regulations 2010 Fire Safety Approved Document B, Requirement B3. Evidence of the fire protection material has passed fire tests, i.e. certificates or approvals. All designers should be consulted to identify any conflicts if the stated fire protection material would cause a detrimental effect on anything stipulated from other designs. So, for instance, some fire intermittent material can have a detrimental effect on steel pipes. It generates and speeds up the corrosion process. Therefore, evidence of this two-way communication must be recorded and filed. And then it's the installation and maintenance information to be stated. So where are the inspection hatches and what level? How do we get access? The designer or contractor then needs to ensure that the fire stopping material stipulated is in fact the material that's been delivered to site. So that would be evidence through photos, delivery notes, videos, etc. The stated fire stopping material which is being delivered to site is indeed the material used to create the fire compartmentalization. So again, videos, photos, delivery notes. And then the breakthrough is clearly identified on a drawing and incorporates the above information. So all of that information above should be on that drawing. You would then need to confirm the contractor's suitability and then confirm the installer's skills, knowledge, experience and behaviour. And then you would obtain an installed a verification certificate and then prepare the operation and maintenance information. That's for the O&M manuals. So that's example 1. Example 2. You need to ensure that you're capturing information which will apply to the building or buildings as from October 23. For example, if a structure is currently being designed and the planned handover is on or later than October 23, which it would be now, you must have the required information and assurance. As an example, if an extractor fan is fitted, then this falls into the Building Regulations Part B, Schedule 1. The fire safety order applies the day you hand the building over, therefore the information you would need to provide is as follows. Has the smoke extraction fan been designed with consideration to the scope of the building? Is the required certificates available? Is the extractor fan compatible with the rest of the building? Does the extractor fan comply with the overall fire strategy? What are the servicing and maintenance requirements? Is a drawing available identifying the extractor fan by either building, location, floor, room, etc.? All the above needs to be handed to the client in a format it can be reviewed and read easily and can be amended when required. You'll need to obtain and file the documents as the project develops as part of the Building Regulations and Building Safety Act. This is part of the golden thread of information. And then I put, can you imagine trying to collect this information after the build is complete? So if you had a building that started around August, September, October 23, and that contractor has completed their work and you're now a year on, how are you going to retrieve all of that above information? It'd be a nightmare. So, building control, a new unified professional and regulatory structure for building control, including registration of building inspectors and building control approvers, and oversight of competence and performance by the building safety regulator. The regulator will establish OSRs or operational standard rules for local authorities and registered building control approvers, as well as having the power to investigate anybody that's failed to meet the rules. The HSE launched a consultation on the operational standard rules on 30th of August, which concluded on the 25th of October. The regulator will secure compliance through a robust set of enforcement measures, including improvement, serious contravention notices, which will give the power to intervene and investigate breaches and direct building control bodies to immediately rectify unsafe practices. The regulator will further hold building control bodies to account through strong enforcement sanctions, which include both civil penalties through the justice system. So they have three main functions. I'm just conscious of time. The BSR has three main functions: overseeing the safety, performance and standards of all buildings, assisting and encouraging the built environment industry and building control professionals to improve the competence, and leading implementation of the new regulatory framework for high-risk buildings. At the heart of the government's reform is the creation of the first national across England building safety regulator. The new regulator's got three main functions: leading the delivery of new, more stringent regulatory regime for higher risk buildings or residential buildings of 18 metres. During the design and construction, the building safety regulator will act as building control body for residential buildings 18 metres plus and hospitals and care homes that meet this height threshold. Overseeing the safety and performance of all buildings and promoting the competence and organisational capability of professionals, trade people and building control professionals working on all buildings. Working within industry and improving the competence of building control inspectors and registered building control approvers. What does this mean for building owners? Well, design and construction of all new buildings is defined roles based on the construction design and management regulations model, i.e. client, PD, PC, designer, contractor. This will apply to all building work, not just high risk building work. Supported by competence requirements, ensuring those carrying out design or building work are competent or trained and supervised appropriately. So again, if you're doing a CDM project or you're doing a high risk building, you would need to demonstrate the competent thresholds of each appointee. That includes architects, lead or main designers, contractors, principal contractors, and that assessment would hopefully be against the BS 8670, PAS 8671 or PAS 8672, because they're the new sets of competence requirements that sets out the requirement for the behavioural section, as well as more information on the skills, knowledge and experience. So design, construction and management of high-risk buildings, a new building control approval regime with gateways, which are stop and go decision points. They require approval before a duty holder starts construction and a completion before the building can be occupied. A new golden thread of building information started during construction and stored and updated throughout the building's life cycle to support the ongoing management of the building safety risks. Introduction of a safety case approach to managing the building safety risk, so the accountable persons must provide assurance to the regulator and to their residents that they've got an effective, proportionate measures in place to manage safety risks on an ongoing basis. There will be mandatory reporting to the new regulator of fire and structural safety occurrences, which could cause a significant risk to life, and those who don't meet their obligations may face criminal charges and ultimately up to 2 years in prison and an unlimited fine. The accountable persons required to register the building, this is a high-risk building with a building safety regulator, carry out an assessment of the building safety risks and take all necessary steps to reduce or manage the building safety risk, produce a safety case report, produce a safety case. So your safety case is explaining what you're going to do and how you're going to do it to prevent a major incident from occurring. Then you would provide a safety case report that sets out how you've done it and how you're going to manage it. And then provide the necessary information to apply for a building assessment certificate when requested by the regulator. So Gateway 1, I'm conscious of time, so I'm sliding on a bit. Gateway 1 is the fire statement. So you'll submit your fire statement, which is here. So you'd have your project plan down to Gateway 1, your fire statement. We've gone through what that is. You then move to Gateway 2. Gateway 2 is where we'd make your appointments, start to apply the golden thread arrangements. But remember, it's a hard stop. So you can't move to Gateway 3 until Gateway 2 has been successfully passed. Then Gateway 3 would be your golden thread of information, and the regulator will then issue completion notice. New requirements regarding the delivery of the golden thread of information through the building's whole life cycle. I put an additional note there for you. There is various documentation required in addition to competence declarations and compliance declarations for all buildings, such as the construction control plan, the control plan and log, a fire and emergency file, etc., etc. So Planning Gateway 1 ensures the consideration of fire safety matters as they relate to the land use planning are incorporated at the planning stage for schemes involving HRB. Gateway 2 is before building work commences, and it replaces the building control deposit of plans stage before building work starts. And Gateway 3 when building work is completed. That'll occur at the current completion or final certificate stage when the relevant building work is complete. Again, I've put in bold Gateway 2 and 3 as stop and go decision points that must be passed before a development can proceed to the next stage. This strengthens the regulatory oversight of the design and construction. The building safety regulator will oversee building work as the building control body for HRBs, and it will work closely with local authorities, fire and rescue authorities, and it will bring in external technical experts as necessary to make sure that the right specialist and regulators are in place when making decisions on applications. Local authorities will remain the building control body for other buildings. Gateway 1, I'm not going to read all this, but you can see from this drawing that the height of the top story excludes the rooftop plant area, so you wouldn't include that as part of your measurement. You would start from here, but that would come down to the lowest level. Fire statement to contain the principles or concepts and approach relating to fire safety that's been applied to each building in the development and the site layout. Emergency vehicle access, water supplies for firefighting purposes. What, if any, consultation has been undertaken on issues relating to fire safety of the development and what account's been taken of this. How any policies relating to fire safety in relevant local development documents have been taken into account. Gateway 2 and 3 will provide a rigorous inspection of building regulation requirements, ensuring building safety is considered at each stage of design and construction. It requires a golden thread of building information to be created, stored, updated throughout the building's life cycle, and requiring a mandatory reporting to the BSR of fire and structural safety occurrences which could cause a significant risk to life safety. The new regime will strengthen regulatory oversight before building work commences throughout construction, including before major changes are made and before a building is occupied. I've put this on to give you a bit more information so you can see the type of information. So for planning stage design, need for industry-wide standardisation for golden thread. And there is a need for a greater level of survey detail with regard to the existing fire stopping and services compartmentation in refurbishment projects. So this is a refurbishment project and you can see the extensiveness here. The golden thread is both information about the building that allows someone to understand the building and keep it safe, and the information management to ensure that the information is accurate, easily understandable, and can be accessed by those who need it, and it's up to date. And it's the duty of the people responsible for the building to put in place and maintain a golden thread of information. Going forward, the information management for safety will need to be embodied across the sector. Again, there's a link there if you want more information on that. Golden thread incorporate all the information needed to understand the building and how it should be managed so that the building and above all the people in and around the building are safe both now and in the future. Make information easily available to the right people at the right time and put in place a new high standard of information keeping which will support the building safety regulator in being assured buildings are being managed safely. Implementing of the golden thread will require individuals and organisations responsible for a building to have good information management systems and a clear understanding of how information management supports building safety. Going forward, the information management for safety will need to be embodied across the sector. I've put here the powers to mandate the golden thread, building regulations, notification and provision of report, mandatory reporting requirements, and keeping information about high-risk buildings. The accountable person for a high-risk building is required to give prescribed information or a copy of prescribed document to the regulator, accountable person or PAP, residents of the building, owners of residential units in the building, or any other person, prescribed person. In order to ensure effective management of the golden thread or safety case, etc., there'll need to be an appropriate safety management system in place. I put here the regulations will prescribe what information and format is to be provided in such that the thread can be passed on to the next PAP or principal accountable person if and when appropriate, either by sale or disposal, information relating to spread of fire, structural plans, drawings, building assets, maintenance, testing, and competence of those delivering the above. Key message for the golden thread is assurance records will be needed on all projects. The information requirements during the construction are different to occupation. Digital management of data is essential, and data management planning needs to be one of the first activities. I've put on here a bit of a flowchart for assurance. So confirm designer organisation is capable, confirm skills, knowledge, experience, behaviour of designer, and then you record that competence that forms part of your golden thread. Select your product, verify certificate, verify compliance with other products. Is it being specified in the building regs? Product certification, that sits as part of the golden thread with a digital assurance. You can follow these yourselves. Typical information, it must capture all sections of information in a file. Select the product, fire and structural safety, certificate, and tested for conditions to which it's going to be used, i.e. within walls or its features. Fire stopping compound, make sure it's compatible. Installation and maintenance information, designing how maintenance can be done. Contractor duty, the product is in fact the product specified from delivery to installation. Again, evidence required. Confirm the contractor's suitability, confirm the installer's skills, knowledge, experience and behaviour, install the verification certificate and prepare the O&Ms. There's a new regulator for construction products, a national regulator. I'll leave you to read this. I'll talk around it. I'm fully aware of some of the issues we've got where one supplier is putting a product on the market which is being tested and complies with the building regs, and then another supplier has put a product on the market that's been tested and certificated in line with the building regs, but then there's no comparance certificate to say that material A has been tested in conjunction with material B and there's no detrimental effects. So that part is missing, and supplier A saying we're not paying for it, supplier B saying well we're not paying for it. So that's where it's falling down at the minute, but I'm sure they'll come to some kind of arrangement. There's new powers so that all construction products marketed in the UK fall under the regulatory regime, allowing them to be withdrawn from the market if they present a safety risk. After an implementation period, the manufacturers of safety critical construction products included on the statutory list will be subject to the requirements, including labelling of products, declaring the performance and ensuring the consistencies meet the declared performance standards. Enforcement powers for all existing and new parts of the regulatory regime to the Secretary of State, which will enable us to build up national oversight and central government trading standards. Enforcement powers will be extended under the existing regime to the new regulatory requirements, and the national regulator for construction products being established within the Office of Product Safety and Standards to provide a stronger oversight at national level. Okay, we're nearly there, ladies and gents. So competence, I just wanted to cover this in the final slides. Competence is the requirement relating to the skills, knowledge, experience and behaviours of an individual. B, the capability of a person other than an individual to perform its functions under the building regulations. The regulations may require an appointed person who is not an individual to give an individual acting under its control, who has the appropriate skills, knowledge, experience and behaviour, the task of managing its function as an appointed person. BSI is building a framework of documents which will raise the standards of competence across the built environment. I've already said BS 8670 built environment is the overarching framework for competence of individuals. Just back on this one slightly, I'm currently working with a few local authorities where they have an AP who's responsible for doing safety case reports or notifying the HSE, which they should have done a while ago. But they still don't understand what their requirements are as an AP or a PAP. So currently working with them, but it is difficult. Also under the BSI documents is PAS 8672, which sets out the competence of an individual principal contractor, and PAS 8671, which sets out the individual competence of individual principal designers, and PAS 8673, which is the built environment competence requirements for the management of safety in residential buildings specification. BS 8670 has been created in response to the findings from the ACCURATE review. This review highlighted a fragmented approach to and lack of consistency in the process and standards for assuring the competence of those working on buildings as a major flaw in the current regulatory system. Accordingly, BS 8670 now provides a set of core principles of competence, including leading and managing safety, communicating safety, delivering safety, risk management, regulations and processes, building systems, ethics, and fire and life safety. PAS 8671 addresses competence thresholds that individuals are expected to meet when managing the duty functions of the principal designer role. It also specifies the minimum competence thresholds needed by principal designers and the additional requirements for working on higher risk buildings. Please remember this PAS 8671 applies to CDM, but it has additional requirements if working on higher risk buildings. Some people out there think these only apply to high risk buildings. These apply to all building work. PAS 8672 can be used as a benchmark against those to which assess competence of individual principal contractors. Can also help the principal contractors determine their own competence limitations and identify any areas for development. And PAS 8673 anticipates a competent senior manager within the organisation to be in place with overall responsibility to manage the resources necessary to deliver on Part 4 of the Building Safety Act. The organisations will need access to competent advice. And that is the end of the presentation. I think we're about bang on time. So, Daniel, would you like to come back on? Unfortunately, we've not got time for questions, so I can only apologise for that. But if you want to write into Julie at IIRSM with any questions, I'll try my best to answer them and get them back to you as soon as possible. But apart from that, thank you very much for your attention and your time today listening to this presentation, and I hope you've found that of some use.
Thank you, Ray. You'll be needing a rest after that presentation, won't you?
Yeah, can you see now why I said there won't be time for questions?
I think Dan must be having some sound options, so I'll finish off today. So if anybody has got any questions, if you want to send them into branches@iirsm.org, and then I can get those across to Ray. But thank you so much, Ray. I'm always amazed at how much you can fit into a presentation. And just to let everyone know, I will send a copy of the slides to everyone that attended today, and you can click on the links in there to get further information, as Ray suggested. Getting lots of comments in saying thank you, really good presentation, thank you. And if you wouldn't mind taking a second to complete the feedback survey after the webinar, I'd be really grateful. So that just leads me to say a huge thank you to you, Ray, for doing this webinar for us today and giving up your valuable time. And thank you for everyone for attending today. And we look forward to seeing you at the next IIRSM branch meeting. Goodbye, everyone.
Thank you very much. Bye-bye.